In the matter of the Prudential Assurance Company against Commissioner for His Majesty's Revenue and Customs.
Lady Simler will explain the judgment which was handed down on the 11th of September.
This appeal concerns the relationship between Section 43 of the Value Added Tax Act, which lays down rules about VAT groups, and the provisions, both European and domestic, that deal with the time at which services or goods are treated as supplied for VAT purposes. Section 43 allows companies to choose to be treated for VAT purposes as members of an entity known as a VAT group. Once a VAT group is formed, the business carried on by the members of the group is treated for VAT purposes as carried on by the appointed representative member, and supplies of goods and services between members of the group are disregarded so that no VAT is payable on the intra-group supplies. The question in this case is how the VAT group disregard applies when between the time services were performed and the time VAT invoices for those services were issued, the supplier left the VAT group. The answer depends on the proper understanding of the effect of the time of supply rules set out in the Principal VAT Directive, the VAT Act, and Regulation 90 of the Value Added Tax Regulations 1995. The VAT Act provides that VAT on any supply of goods or services becomes due at the time of supply. The general rule is that a supply of services is treated as taking place at the time when the services are performed. There are exceptions, most relevantly here, Section 6, subsection 14 and Regulation 90 of the regulations together provide that where services are supplied over a period and the whole or part of the payment is made periodically or from time to time, the supply is taken to occur at the time when the supplier issues a VAT invoice or when payment is received. In this case, a company called Silverfleet performed fund management services for Prudential when they were both members of the same VAT group. At the time the services were performed by Silverfleet, and when Prudential paid the management fees that were due, those supplies were properly disregarded for VAT purposes. However, years later, Silverfleet stopped managing funds for Prudential and left the VAT group, and at that point success fees were triggered when the value of the funds exceeded a contractual hurdle rate, and Silverfleet issued invoices for it in 2015 and 2016. The issue in the appeal is whether VAT is payable on the success fees because Prudential and Silverfleet were no longer in the same VAT group when Silverfleet invoiced Prudential for them, or whether the fees are not subject to VAT because they arose out of services that were fully performed and in that sense completed while they were in the same group. HMRC decided that VAT was properly payable. The first-tier tribunal allowed Prudential's appeal, but that decision was reversed by the upper tribunal and the majority of the Court of Appeal. The Supreme Court dismisses this appeal. Lady Rose and I give the judgment with which Lords Reed, Hodge, Lloyd-Jones, Stevens and Richards agree. We sat as a panel of 7 because one of the arguments put forward by Prudential invited the Supreme Court to disagree with 3 earlier decisions of the House of Lords, if those decisions couldn't be distinguished. In the judgment, we discuss the 3 House of Lords decisions in detail and summarise their effect. We conclude, in agreement with the Court of Appeal, that Section 43 of the VAT Act is not a complete code with its own time of supply rules. Instead, it must be read with Section 6 of the Act and the regulations to determine when a supply between members of the same VAT group took place. The Court of Appeal was therefore correct to apply Regulation 90 sub 1 in order to determine whether the supplies that triggered the success fees are treated as having taken place while Silverfleet was inside or outside the VAT group. We conclude that the reasoning of the House of Lords in the 3 earlier cases supports that outcome. On this basis, Regulation 90 sub 1 has the effect of splitting the supplies made by Silverfleet that are ongoing or that attract successive payments into a series of separate successive supplies, and each successive supply by Silverfleet is treated as different in time from the one before. In other words, the timing of the supplies to which the success fees relate is modified by the successive payments of the success fees, so that the services are treated as having been supplied at the time the invoice was issued or at the time of payment. Given that conclusion, which was based on domestic law only, the judgment went on to consider a new argument raised by Prudential, namely whether Regulation 90, as so applied, is a permissible domestic implementation of Articles 64 or 66 of the Directive, as those articles have been interpreted by decisions of the Court of Justice of the European Union, decisions which predate the UK's withdrawal from the EU. Prudential's case is that neither article can be relied on as permitting Regulation 90 to be applied in this way. We agree with Prudential that Article 66 cannot be relied on because it only gives member states the option to postpone the time of collection of VAT to the time of invoice or payment. It doesn't alter or affect the time of the chargeable event. The question is therefore whether the modification made by Regulation 90 sub 1 to the time at which the chargeable event occurs is a permissible implementation of Article 64. We hold in the judgment that it is. The wording of Article 64 is wide, and it does have the effect of modifying the time of the chargeable event as well as the time of chargeability of VAT. The judgment recognises that Article 64 has been interpreted restrictively by the Court of Justice in a number of cases. We discuss those cases. However, consistently with those cases, we hold that Article 64 can apply where the reason why the supply of services gives rise to a successive payment is because, as in the present case, the parties to the contract do not know at the date when the services are performed or when continuous performance of the services comes to an end, whether any further payment will ever become due, or if it does, in what amount. In this case, it only became clear that success fees were payable when the contractual hurdle rate was crossed. That was after Silverfleet left the VAT group. In other words, Article 64 applies to supplies the nature of which justify payment in instalments and can include situations where the payment for services is uncertain or contingent at the time the performance of the services is completed, and where the successive payment comprises an element of payment that crystallises only once the uncertainty or contingency is resolved. Here, the payment of the success fees by Prudential to Silverfleet was a successive payment within the meaning of Article 64. Accordingly, the answer to the question whether the services were performed for VAT purposes at the time Silverfleet was in the same group as Prudential is no, so far as the success fees are concerned, because the chargeable event to which the payment or invoices for those fees relate was modified or postponed to the extent of the value of the services reflected in the later 2015 and 2016 invoices.
Thank you.